Well, yes, we will talk about that placeholder matter in a moment. Yes, we also have been joined by Mr. Adegboruwa, Senior Advocate of Nigeria. Good morning, and thank you for joining us on the program today. Well,
good morning, Chebalin. Good morning, Nigeria.
Yeah, ever since we spoke, so many things have happened, these days in this country. Before you say Jack Robinson, several things have happened in quick succession, But now, let's start off with the lawyer, when he got to the courts and came in that attire, and he says, well, the judges were I think they were pleased with him as a result of the Supreme Court judgment. That's why he wore this to court. But I mean, Nigerians know how the noble profession, as you refer to it, prim and proper, you're expected to be, appear before, your lordship. But coming with this, what does that, look, what goes through your mind when you saw this?
Thank you, Chemalin. I think that, I believe Learned Counsel did not appear before the Supreme Court as a lawyer. Number one, he had no case before the court. Number two, he was not representing any party before the court. Number three, no matter was listed on that court list requiring his appearance as counsel or legal representative for any party. So I would take it that he went to that court as a Nigerian. It will probably be a coincidence that he's a lawyer. And he went there to make a statement to the Supreme Court, I believe, in relation to the judgment of the court concerning the freedom of worship, religion, the freedom of conscience, and thought. And I think the statement probably he is making is that there's need for caution on matters relating to law and religion. Because, I mean, generally, religious matters should be matters reserved for private observance. And the states and our institutions need to exercise some caution between enforcing the rights of others and also protecting the rights of others. I have since got to learn that the wearing of hijab, especially when it's properly regulated, is part of the tenets of the exercise of the Islamic faith. And that needs to be accorded sufficient respect because I also did some study and discovered that perhaps that is part of the principles governing the exercise of that particular faith. But the thing is that the Supreme Court ought to have weighed in respect of judging the exercise of that right with the right of others, because I'm situating the judgment within the context of attending public schools, because the case started in Lagos State, where pupils who were attending public schools were not allowed to dress in a manner that accords with the exercise of their faith. So it shouldn't be a generic decision that will probably cause some kind of controversy nationally. So I believe that the context of that judgment is limited to the issues before the court, to the extent that in public schools, where everybody is allowed to attend, you will not discriminate against people on the ground of the exercise of their faith. But Chamberlain, the exercise of that right is also must be weighed against the rights of others. For instance, maybe you opened a private school and it's your money that you deploy to open that school, and then you open it to people to attend. For instance, these private universities, maybe it's an Islamic school or a Christian school. You wouldn't take these judgments to, for instance, a private Christian school funded privately by the owners, and then insist to impose your own faith upon them on the basis of the Supreme Court judgment, or you go to an Islamic school, or you seek to impose your own Christian doctrine upon them based on the Supreme Court judgment. So I think that there's need for proper definition so that we don't cause undue controversy. But so, for my learned friend, I think he went there to make a statement, not as a lawyer.
So if he had a case listed and it was appearing for someone before the judges, can he not appear like that because he's trying to give the impression that he can, perhaps saying that the court is a public place?
Well, I think that it's for the court to give a proper interpretation as to whether he can appear. But as a member of the legal profession, we have our own dress code. We have our own rules guiding appearance in court. You know, because in the judgment of the Supreme Court, the case made by the people who took the case to the court is to the effect that there's no regulation in Lagos State in force on what should be worn in public schools by pupils who attend those schools. And so to that effect, there was nothing to discriminate against anybody who appeared in the exercise of their faith if it's required. But in the legal profession, just like in the journalistic profession, in the churches or other professions in the armed forces, there must be a regulation for appearances, for dresses, you know, and if you violate that, you may have to face the internal procedure for discipline within those particular professions.
So if we hypothesize a bit, if the state had laws concerning dress code, will the case have appeared, or the judgment have appeared, or have been ruled differently on that particular matter?
I think that was the point made, because, you know, our Constitution, the rights granted in the Constitution are not absolute. Section 45 of the Constitution allows the government, the National Assembly, and lawmakers to make laws to derogate from the rights granted under the Constitution. So I think the point that the Supreme Court was making is that there is no law made by the House of Assembly of Lagos State derogating from the rights to freedom of religion, freedom of expression, assuming the Lagos State government had made a regulation prescribing the kind of uniform to be worn in public schools, and then there is a violation, then I mean it will be justified to deny people attending those schools. So you must situate every judgment within the facts of that case. And I don't think the judgment of the Supreme Court is a blanket expression of taking dresses to public places anyhow. It was limited to the issue of the Lagos State circumstance, which did not have a law in place prescribing which uniform pupils should wear in secondary school. I don't think that would be a precedent for instance, a Christian to go to a mosque and say, because it's a mosque and a judgment of the Supreme Court, you will wear a cassock. Or for a Muslim to take a hijab and enter a church and insist on participating in the activities of the church. I don't think we should interpret it to that extent. And I think that it's important that the court should more or less stay away from religion. Nigeria cannot be described as a religious state. We're a secular state by virtue of Section 10 of our Constitution. So we need to be cautious because of the sentiments attached to religion generally in Nigeria.
And I think it's important to make that point because people watch and they might get conflicting signals, essentially. But since this is about the Lagos State issue, particularly, I mean, you're taking this case by case. So first, a student today, based on that judgment, can appear in school with the kind of dressing that we saw the lawyer in. Is that true? Is that correct?
I think that as of today, if Lagos State government is yet to make any law prescribing the kind of uniform to be worn by pupils who attend public schools, and I emphasize public school, the Supreme Court judgment is not applicable to private schools. So if there is no law, it's possible for Malane French Chief Omoebo, as he has threatened that his children will attend school in that regalia, it is possible for them to appear in that regalia in public schools. If Lagos State is yet to make any law prescribing the kind of uniform to be worn by pupils attending its public schools, it's possible to appear in that regalia, sir.
You know, so I see people perhaps trying to then extrapolate this, maybe even take this further. And the joke has been made that some employees might appear at work, you know, judging from that particular Supreme Court pronouncement and say, well, I have freedom, religion, you know, freedom of association to thought and all of that. And they can always have that Supreme Court judgment, at least to show the employer. So is that taking it too far as well? I know you have said, you know, we should, I mean, the court should maybe stay away from religion, but clearly they have mixed so far, and we don't know how far this will go. So just to guide someone who might want to try that, is that the way to go, or are you calling for caution?
Absolutely, that's not the way to go. For instance, private companies have regulations on dress code for their members of staff. And if you go as a member of staff of that organization and you run contrary to the existing regulation on dressing, of course, it's a contract of employment. Your employment can be determined on that basis, and you will not have any remedy at all in law. And you cannot rely on the Supreme Court judgment to violate the contract you signed, willingly agreeing to abide by the codes of ethic of your company. So it cannot be a basis at all for people to claim to wear any dressing to appear anyhow. And I think, Kyle, honestly, because I told you that I have, in the course of my engagement in this matter, also got to know that even the hijab itself, it's not supposed to be all manner of coverings. It's a particular way of exercise of faith by which female adherents of the Islamic faith are expected to cover their hair. And I think it should be moderately done, so that it doesn't also elicit reaction from other people. So if you want to wear the hijab, for instance, especially in public institutions, it will be probably in exercise and demonstration of a moderate exercise of that faith by covering the hair. But when you do it in such excessive way, it may also provoke the kind of thing that the lawyer has done. So I think the useful guide is to be moderate in the exercise of the rights that is being granted by the Constitution.
Mr. Adegboruwa, I pick up on the first point you made, that the lawyer went there not as a lawyer, but as an individual making a statement. But right above that satirical attire was his lawyer's gown, and atop his head was the wig. So that apart, then secondly, which should be the strongest lesson here? The first point that you made about the Supreme Court should be careful in making judgments, by being sensitive to other people's rights besides a section of the population, or the fact that the Lagos state government hasn't made any law about how students should dress to school, hence perhaps it's a free-for-all. Your other pupils can decide what to wear to school. So which lesson should trump the other right now?
There are three things I would like to state. And it's that for the practitioners of faith, whether Islamic faith, traditionalists, or Christians, we do not set out to provoke embers of crisis in a nation. We need peace in the land for there to be development, for there to be growth. These schools are already in existence, especially the private schools. You know the nature of the schools you want to attend. For instance, let's say a university set up by missionaries. It was particularly set up for a purpose. And if you want to attend that school to benefit from the objective of the owners of the school, you can't use your own religious faith to disrupt their objective or planning. Otherwise, there will be a different motive to that exercise. But at the same time, when it relates to public institutions, the government has a duty to make laws to guide human conduct, because the confusion in this is placed purely at the doorstep of Lagos state government, which has refused to make laws regulating appearance of pupils in public schools. And I think now that the Supreme Court has delivered this judgment, I expected Lagos state government, the House of Assembly, and all the leaders of thought to meet together with the institutions, the religious organizations, and agree on specific modes of dressing that will accord with the rights of those who want to practice, but will not also offend on the rights of others who probably are not inclined in that regard. So there has to be a balancing. And for the court in particular, before I end on this, the Supreme Court is a policy court. When you give a decision, it's a final court. I believe that in the exercise of the decision in respect of this hijab thing, greater consultations could have come. When matters like that get to the Supreme Court, they ask for amicus. They invite people. You invite Christian people, you invite Islamic people, you invite traditionalists, you invite the Attorney General, you invite the NBA, because you are about to make a fundamental policy statement that will affect the nation. I believe that the Supreme Court ought to have given opportunities for other people, rather other than those who took the case to court, to make contributions before coming to that decision. And that's why you are seeing this kind of reactions. Because if everybody had been brought into the picture before coming to that decision, it will have been probably well guided, in terms of how to ensure that specific pronouncements are made that will not cause crisis or tension in the polity.
All right, now, speaking about the rights of others, you're also aware of this Senator Ekweremadu matter. Lots of surprise when the news broke, and still many trying to grapple or understand and process all of the information that is just coming through. But for the part that you have read and heard, yes, it's a legal matter largely. What do you think of it?
Well, Chamberlain is quite unfortunate. And I think we pray as parents never to be in this circumstance where the love to save our children may conflict, with laid down regulations and rules. And I think it's an eye-opener for all of us. It's about the circumstances of how we exist in our nation, Nigeria. That for you to undertake such important venture, you needed to be well guided legally to ensure that you follow due process. For instance, it's alleged, for instance, that the reason why the boy was asked, that's the donor, to come back was that his blood type did not match the blood type of the lady that was to be assisted. So which means that due diligence was not done. Because before you enter into such undertaking, at least the first thing is to ensure that the person that you are taking there is in him. And then if it is true that he's a minor, who is the guardian? Who is the parent? Who are the people who you consulted to be able to get their consent? Because a minor in law has no right to grant consent for such an undertaking. But this case is still in the realm of social media and newspaper publications. We've only heard from the Metropolitan Police. We have not had the case of the defendant. For instance, there's a document circulating online by which it is said that Senator Ekweremadu informed the British Embassy in Nigeria as to the purpose for which the donor was being taken abroad. But that it would not exculpate him from complying with due process. For instance, if the donor is a minor, the fact that you inform the embassy will not discharge you from fulfilling the requirement of the law to get the consent of his parents or guardian in order to undertake such a venture. What are the medicals you have carried out? And I think it's a lesson also for our leaders. So many things we do in Nigeria and get away with, we can't practice it abroad. And that's what the point we make every time, that we can get this country moving if our leaders do things right. Because, a person in that capacity, given his status, he will do it in Nigeria and nothing will happen. So, but my sympathies goes to Senator Ekweremadu, having regard to the fact that he undertook this assignment as a way of rescuing, his daughter. But he has to do that with caution, so that in trying to rescue your daughter, you don't endanger the life of another person who is also a human being. So I think that we should wait till July 7 when we hear his own defense before we'll be able to say this is what is actually the case.
Indeed, Mr. Adegboruwa, as you rightly pointed out, the facts of the matter are still very sketchy, and there have been so many attempts to try and dig behind the scenes to see just what is happening. Emerging also that the boy in question, or the donor, would-be donor in question, was also said to have was not a match and was supposed to return to Nigeria, and as a result decided to seek asylum Well, as you rightly pointed out, by July the 7th, we should be getting more information, maybe even as the day goes by, as to what exactly transpired in this particular matter. But let me quickly take you back to that Supreme Court judgment and the appearance of the lawyer in court, because some people say that, I mean, as you've also rightly pointed out, that that judgment has implication for the country. And we currently know that in Kwara, there's still a tussle in that regard. And some people think that the Supreme Court judgment has settled it. From what you know as a lawyer, did the Supreme Court judgment also, because if it was given in respect to a judgment in Lagos, has it also settled the matter in Kwara?
I don't think so. I beg to disagree because as lawyers, what we say is that every judgment is limited to the facts of that particular case that provoked the dispute. And in this particular case is that Lagos State public schools were said to be available for people to appear there, in any dress that suits the exercise of their faith. The circumstance in Kwara is totally different. I understand that there are some missionary schools that were released to missionaries. And for instance, in one of the schools in Kwara, there is a church inside the compound. There is a school inside the compound. So people attend that school in order to have access to education. So in that circumstance, it's a delicate situation that is different from Lagos. For instance, if a church is going on, maybe a weekly service, and then the school is also going on, and you see priests wearing their regalia, you see Islamic adherents wearing their hijab, you see Olokun people, you are desecrating the church because you actually knew that it was a church before you enrolled to be in that school. So I believe that the circumstance of Lagos State is totally different from that of Kwara, and that we may not apply the ratio of this case to that case. But I think the Kwara State government has since taken steps to engage all stakeholders towards a resolution of the issues, because there's no reason why religion should cause problem for us in a nation where we have no food, there's no electricity. I mean, I believe that it's our leaders who do these things as a means of trying to curry favor from the populace, probably for the purpose of electoral value.
Well, I was also going to point out that to some extent, I think Oshun also had a bit of that particular issue where we also saw children being dressed up. I mean, the very fact that children have now been involved in this, also raises questions. I think as a result of the uniform dressing across all the schools in Oshun, there were questions as to how, people of certain faith should dress. And before you know what's happening, parents were dressing their children in choir robes to school, etc. And even I can't remember what it's called now, but the outfit that white garment churches wear to their places of worship, and children were dressed in that to go to school. So there have been questions. This is not the first time we're seeing that, but for a lawyer to be making such a statement, there have been questions as to just what exactly it will take for us to be able to reach a decisive statement, make a decisive statement as a country, so that perhaps this sort of conflicts or opportunities for conflicts can be resolved once and for all. Do you see how that can be done? Since you now say that it could be on a case-by-case basis that this needs to be taken up.
I believe that the way we should approach this matter is to try and be universal. When I say that, we look at other jurisdictions where people practice their faith, either to cover their hair or to cover other areas of their body in deference to the tenets of their faith. In the US, people in the army wear hijab. In UK, lawyers wear hijab. So I think that you shouldn't come here and then make it a matter of extremism. I mean, there's no problem in covering the hair. So it's for government to sit down with those who want to practice their faith, whether Olokun, whether Islamists, whether priests, to be able to regulate the exercise of that faith in such a way that it does not lead to extremism. I do not see any problem in anybody wearing hijab, honestly, Maupe. The thing is that you don't do it in a way that becomes the extreme, that you provoke others to also want to exercise their own. So let us agree what is the kind of covering we approve, and what is the kind of uniform that those who say they are priests can wear. And we agree together and sit down, because religion is quite very sensitive for us in the country. And it could provoke a lot of things, where people are killed for alleged blasphemy. So you don't have to take it to such extreme. Let's have some definitions so that if you go out of that context, then you can be dealt with according to law. But where you leave it to the discretion of individuals, then abuse will set in. And I think that's what's happening currently. So the government has a duty to sit down with the relevant stakeholders and agree on a template. You want to wear hijab, what is the area of cover? You want to wear the priest cassock, what is the limit of the coverage? And move on as a nation. I don't think religion should be a national crisis. And it's our leaders who are exploiting these fault lines for their own selfish advantages.
Okay, let's move on to this, the matter which we were discussing earlier, which is about Senator Ekweremadu. As looking at just, what has transpired, and I don't know, he's not been granted bail. Himself and his wife have been remanded in custody until July the 7th, when they give their own side of the story. But do you think that Nigeria has any role in this as we speak?
Yes, Malpe, I think that given the circumstance of what is playing out, I mean, it's the responsibility of our government. It's not even about Senator Ekweremadu. Any citizen of your country that has challenges of this nature, if there is no ill motive, if there is no fraudulent intention, if it's the genuine desire to rescue a daughter who is in distress, I believe any assistance that government should render, it should render it. Because like I said, as a parent, my heart goes out to Senator Ekweremadu and his wife. And I see so many parents go through this kind of agony and distress. But it's just to ensure that you do it in such a way that, there's no further damage that may occur either to the would-be donor or even to the victim who is in distress. So I believe Nigeria should rise to this occasion and offer assistance, so long as this is in exercise of the genuine desire, to intervene in the health situation of the daughter. I think Senator Ekweremadu deserves all our sympathy and prayers. And if there's anything we can do is to offer assistance in terms of legal representation, in terms of diplomatic engagement, but, in the UK, unlike Nigeria, they follow law mostly to the letter, and they will probably take due process in this regard. But by July 7th, like we said, the greater details of these facts will have been out by then, and we'll know what extent of involvement in terms of the alleged infractions of the relevant laws of Senator Ekweremadu and his wife. But at this moment, we can only pray for them and urge the Nigerian government to render any assistance that may be possible.
Yeah, so while at that, I mean, just as you said, July 7, a lot more will be clearer, because some of the information out there just loose ends that we can't seem to piece together. Because if they say that there was a genetic mismatch, it suggests that that might have been found out in UK there, or in a hospital over there. Because if they found out there was a genetic mismatch here in Nigeria, he will not have traveled to UK or something. And then they said he was in the Heathrow airport, that he was arrested. So while it's still unclear, so do you think that, I mean, that information where they say first, that genetic mismatch, does that suggest to you that, well, they carried out all of that test, and one wonders at what point then did they then decide that, or did they find out that he was a minor? So it's still a little unclear.
Generally, it just follows from what we have analyzed in the matter that the senator did not follow due process. And probably, I'm sorry to say, it's just in the exercise of the kind of privileges that our leaders take for granted when they are with us, which is not available when they go to other jurisdictions. Because if this were to be done in the UK, for instance, or in America, it is in Nigeria that you will have established the relevant conditions for transporting the donor. And if you didn't meet that condition, the boy would not have left Nigeria in the first place. So it just means that our leaders get away with anything. Unfortunately, in this circumstance, it has resulted in this because the senator desperately needed to take steps to save the life of his daughter. And I think the lesson there is for all of us, especially our leaders, to set good examples for our people by choosing to follow due process when they are in Nigeria, knowing that when they get abroad, they dare not flout those processes.
The question then will be, what is due process in this case? There's a letter circulating saying that he actually informed the authorities about this process. When you look at the laws in Nigeria, I mean, a lot of people are probably even hearing about this whole situation of organ, is it transplant or harvesting for the first time, really, and it's a new realm for them. In terms of laws in Nigeria, it's not quite clear. I know that there have been some work here and there, but it's still based on the basic principles of, trying to help and all of that. Nothing really concrete. So what will due process be in this case, aside, I mean, if that letter is anything to go by, informing the authorities and perhaps, getting some sort of consent?
A due process, for instance, will involve the medicals. Because even as a minor, the donor could not have traveled to the UK without applying for visa. And in applying for that visa, you will state the purpose for which he was to travel. And that purpose will be that he is to go and donate his organ. And for you to do that, this due process of proper medicals to match the blood of or type of the patient will have been done, because Senator Ekweremadu is a high-ranking Nigerian former deputy president of Senate. Maybe he has a diplomatic passport. Maybe he has waivers. If it were to be ordinary Nigerians who will do this, I mean, it will be that you have to satisfy the requirement that the purpose for which the boy will be traveling has been met. I mean, and for him to go in violation of that due process means that those procedures were not followed. That's what I mean by due process, to say that we should take a lesson from what has happened.
So very quickly now.
But like I said, Kayode, by June. Yes, please go ahead. Land
on the points, Mr. Adegboruwa, very quickly.
No, I was saying that it's just for us that, because the meaning of the reason why these things happen is for us to take appropriate lessons from the event so as to prevent a recurrence in future. Otherwise, if this didn't come into the light the way it has come now, probably many Nigerians are doing this, going to India, taking people abroad, and nothing has happened. So it will just be for the authorities, NDLA, the trafficking agency institutions, and those in charge of immigration to ensure that proper due diligence is done before certain approvals are granted for this kind of purposes.
So let me ask Kayode's question in a different way. The fact that there's a letter circulating informing the UK government of the intention, isn't that transparent enough to show his good intention such that the consent of the boy in question was obtained before the travel? And then again, organ harvesting is a huge word. If the consent of the boy in question was obtained, isn't organ donation the more appropriate word in question here to deploy to describe the situation and as a result could be perceived as legal?
Well, I will answer this question limitedly in relation to the document you said is circulating on the social media. it's possible that the senator obtained the consent of the parents of the guardian. But the letter emanating from him informing the embassy in Nigeria is not the one required under the law. When you talk about consent, the consent will be the document emanating from the guardian, either from the parents, and it will follow some process of law in terms of giving sufficient details to the authorities, the ministries of welfare. You don't just capture a minor and then by yourself, you write a letter to the embassy and say that it's going for this purpose. That does not satisfy the requirement of the law in terms of consent. But like I said, I don't want to prejudge the facts of the case. I'm only answering this based on that letter alone. It's possible the senator had other documents by which he was able to legally procure the consent of the parents or the guardian. And that information itself will not take him away from fulfilling other conditions about medicals to ensure that, the blood group of the donor matches with that of the patient.
Well, incidentally, this happened at a time our president, or on the day our president was meeting with the Prime Minister of UK, Boris Johnson, and they spoke on different issues. We didn't hear that this came up anyway, but regarding the legal and maybe diplomatic angles to this, if you could help us just look into the future, what are the possibilities? This man is, at some point, one of the most powerful men in Nigeria, the Deputy Senate President. That's high-ranking political officer in Nigeria. So what are the possibilities in terms of diplomatic interventions? Is this a case you think Nigeria will take on? Is this a case that maybe will be pushed to bring to Nigeria, maybe for adjudication and all of that? What are the possibilities with this case, Senior Advocate?
Yes, thank you indeed. In criminal law generally, we look at the mens rea. That is the intention, the purpose. Was there a criminal intent in this? From the circumstance of the facts we have, certain factors are indisputable. Is that there is a patient abroad who is a biological daughter of the senator who requires some kind of transplant. Secondly is the fact that he attempted, through the letters by which he informed the embassy, to make full and frank disclosures. So if there were errors along the line, it may not then translate to the fact that it is a case of organ harvesting, because indeed there is no mens rea, there is no motive on his own part in that regard. There is already clear evidence that he indeed wanted to go through a medical procedure of transplant. So I don't think he wanted to go and sell the kidney of the donor or any other organ. So once there is that a case which is not in dispute, I think all other infractions are things that can be looked into diplomatically to see how a soft landing can be obtained for the distinguished senator, if at all.
Now, I know that there are different perspectives that you look at for in law, but on the question as to whether or not the person, the donor, is a minor, that's going to be a key factor in this entire matter. Because the hypothesis is saying, look, in fact, some have seen the images of the person circulating online, and they wonder, is he really 15? So could they have relied on his own verbal submission that I am 15? So if they did, would they not be required to do further proof or tests to verify that he is not 15 or not a minor? And if it happens, it turns out that he's not a minor, will this case fall flat on its face?
Well, there are so many angles to this matter. And like I said, the facts we have are quite very sketchy. For instance, before we commence this interview, I have since seen some kind of rebuttal from the person who is being circulated on social media that indeed is a different person, and that he was begging that people should not link him with this particular matter. The issue you raised about falsification of age is a different criminal offense entirely. If the senator deliberately altered the true age of the donor in order to present him as a minor or as somebody who is an adult, whereas he's a minor. That has nothing to do with organ harvesting. That's a different offense entirely. And I mean, that is something that he has to contend with, even apart from the issue of parental consent or whether indeed the procedure for transplant was properly followed. So there are many dimensions indeed to the matter, because once there is evidence that there is manipulation of the age, and then an offense may have been established. And so it will be for the UK government to go through the relevant procedure to determine the true age of the donor. They will take his blood, they will ask for his birth certificate, they will contact his parents, they will do their own due diligence to verify his true age. And that, if that is not in accord with the age declared by the senator, I'm afraid it may be a big challenge beyond what we currently are speaking about. All
right, so until July 7 then, where perhaps the defendant would have put up his own perspective on what transpired, then perhaps there will also be a lot more dots to connect. And then on to this other matter, which we seem to be contending with, the placeholder matter. Yes, INEC, they seem to be saying different things, even though they'll tell you it's the same thing. But give us your legal perspective on this question as to what the law requires for a placeholder, either for vice presidential slot or deputy governorship candidate, as it were.
Well, I think I should just give a small background, Chamberlain, to say that we've been on this controversy for some time, actually since 1983, as to how do we draw the line between the right of political parties to nominate candidates of their choice to represent their party, and then the right of members of the party and indeed the electorate to choose their own representative. Because I say this because under the Constitution, people have a right to come together to associate for the protection of their interests. So if a political party has been able to gather people of similar interests to represent them, you have to ensure that we draw the line between imposing people on them and then giving them the right to choose who should represent them. So there's been that controversy whether parties, once they have submitted the name of a particular candidate, whether that is absolute, whether they still have a right to determine whether to withdraw or substitute. So it's been quite challenging. In the past regime, the Supreme Court tried to ensure that they place a balance to say once you have submitted, you cannot just whimsically just substitute unless there are certain conditions. And that's what led us to the present, their very best to ensure the sanctity of the recruitment process. Because that is what is at stake here, the recruitment process. Because leadership starts from the primary. The election actually is just a confirmation of that particular process. So this is the foundation of the leadership recruitment process as to who is picked by the political parties to be their candidate to stand for general election. Because these people are the ones presented to the general electorate to approve or reject. So we're also concerned about the foundation because it's important. So to that extent, I believe that what the National Assembly has done is to give some latitude to the political parties to be able to nominate candidates of their choice, but also to insist that those candidates can only emerge from the will of the people. That's why the primary election has become so sacrosanct. And to ensure that whoever emerges from that primary election is not supplanted anyhow without going back to the people who elected him. So coming back to your question, whether there is issue of placeholder, I believe there is a kind of misdirection on the part of the political parties in this regard. And I think it is INEC that we should blame. I'm sorry to say this, and I will explain why I say so. Under the Constitution, Nigerians are fought to ensure that INEC is independent. Our Constitution in Section 159 has clearly stated that INEC should not be under the control of anybody in the discharge of his duties. So if in the circumstance we are, INEC is being pushed by the political parties, and especially, and I say especially, the ruling party All Progressive Congress. Because if you follow this trend, these controversies don't exist in the opposition parties mainly. The PDP, ahead of time, conducted its own primary convention transparently. Less than some days thereafter, the candidate of the presidential candidate had already nominated his substantive deputy. Nothing like placeholder. You know, before this time, the All Progressive Congress pushed INEC even to extending the deadline for the holding of presidential primaries. So I believe that INEC is giving the impression that it is submitting or surrendering its
but they told us it was IPAC
to
that did
the
that.
ruling party in particular.
Can you hear me?
Well, IPAC is a conglomeration of, I can hear you. IPAC is a conglomeration of the political parties, indeed. And the impression cannot be erased anyhow that the president of the Federal Republic of Nigeria, being a member of the All Progressive Congress, is clearly exercising some influence, you know, over the electoral umpire in the circumstance of what we have seen so far. So INEC should insist on its independence. If you have submitted the name of a candidate as a presidential candidate and as the running mate, you have to go through the conditions stipulated under the Electoral Act. If at all there's need to substitute, but indeed there is a right to substitute under the Electoral Act, following certain conditions.
And that's what I'm about to read, Mr. Adegboruwa. This is what the law says. The vice presidential candidate, for there to be a substitution, the vice presidential candidate must write to INEC with a sworn affidavit saying that he's withdrawing from the race within the time frame provided by the law. So if the law says this, even though it doesn't recognize the name placeholder, some lawyers will say as a result, what the law doesn't frown at, it allows. So in that regard, are the political parties still in order by making available a surrogate, using another word now, pending the time frame that they're allowed to replace?
No, that place you read, you know, is not in the Electoral Act. It's probably a contraption of INEC, as it were. But it is true. But it's a paraphrase of the Electoral Act. The only problem, however, is this. In case of the president, the governors, they have deputies. The senator is not required to have to nominate a deputy to stand for election. This controversy is only limited to the presidential candidate and the governorship candidate because they are supposed to, at the same time, nominate their deputies or vice president. And to that extent, the vice president or the running mate of the presidential candidate or the governorship candidate has no independent power of his own to contemplate writing a letter to INEC or any other institution to say, I'm withdrawing. He is subordinate to the presidential candidate. They sink or float together. He has no independent mandate of his own because he was never elected at any primary convention. At the time that Senator Asiwaju Bola Ahmed Tinubu was elected by APC, there was no running mate elected along with him. At the time that Atiku was elected by PDP, there was no running mate elected with him. So he has that ticket in conjunction with his own political party. So the candidate that he nominates to INEC to say, I'm withdrawing, there's no such power. It is the candidate and the political party themselves that have the power to say, well, we want to substitute our candidate, and that this is the reason why. Maybe the person is withdrawing, maybe the person is dead. So the controversy here is that the Electoral Act did not make reference in any way at all to circumstances of what will happen to a running mate or a deputy governor in that instance. And that's where there's a controversy, which I'm sure is part of the challenges we have generally in the Electoral Act. An act that is not up to 6 months that it was signed. There's so much controversy. The legislators themselves are up in arms asking the president to amend Section 84.8, you know, and then this controversy again about the running mate. So, and I think it's a lesson to the legislators generally that they need to sit down and do a thorough job, you know, on legislations so as not to cause greater controversy because it's too early in the day. after the amendment of the Electoral Act, to be having these kind of controversies. So I said clearly that there's no position or law empowering a running mate to write to INEC to seek to withdraw. It's not recognized under the law. In the eye of the law, he has no power to write a letter to INEC at all.
And INEC has said same, that there is no form submitted by the political parties saying that this vice presidential candidate is a placeholder. So what's the implication of this now? Does it mean that if the party is now writing in the next couple of days to say that we're replacing this name, INEC will not recognize it?
Well, you know, what will happen is this. For INEC to seek to substitute, for a political party rather, to seek to substitute a running mate, it must also withdraw its presidential candidate. Because the running mate has no independent power. It has no independent value in law, you know, in the Electoral Act. So if you need to substitute that ticket, you have to first withdraw the ticket of the presidential aspirant himself, you know, and that would then give you the opportunity either to go for a fresh primary or to nominate a fresh person. So there's no place, that's why we say there's no place for placeholder. You know, because you cannot take away the ticket of the running mate and leave the presidential person empty. Because for you to withdraw from, for instance, to say you are withdrawing, what is the name of this man in Katsina that has been placed by, I think it's Kashim. For you to say you are withdrawing Kashim from the ticket of Asiwaju, you can't leave him empty. You have to take away his own ticket also, because you cannot leave the name of Asiwaju Bola Ahmed Tinubu with INEC without a substantive running mate. So you need to remove his name first and then come back with his running mate. That's why we say it's not possible to be done in law. To say you are writing to INEC to say we withdraw Dr. Doyin Okukwe as running mate to Mr. Peter Obi. You can't leave Peter Obi alone in the tickets.
Incidentally, today is the last day, or at least today is the day for the publication.
No, I can't hear you.
Okay, can you hear me now?
Yes, please.
Oh, great. I said incidentally, today is the final day for the publication of, you know, the personal details and particulars of candidates of the parties, especially for Presidential and National Assembly, the EC9. So one will wait to see how that plays out. But are you saying, in essence, that once that publication is done, we see the name of the candidate and the running mate, the name of the running mate cannot be withdrawn or at least changed, except you also change the name of a candidate? So let's use, for example, for the APC. So we have the presidential candidate and a running mate. So if you say that if you want to change or replace that running mate, you also have to change the candidate. Is that what you're saying?
Let me break it down, Kade, for you to understand that that's what I'm saying. In the Constitution, because it's the Constitution that gives the conditions for qualification to aspire to the position of president or governor. And I have said that this controversy is only limited to the offices of the president and the governor. So what the Constitution says clearly is this. At the time a political party is fielding a candidate or submitting the name of a presidential candidate, that candidate must at the same time nominate a deputy. You cannot submit the name of a presidential candidate alone without a deputy. And we have a precedence in this matter. You remember the case of Alhaji Atiku Abubakar. He was governor of Adamawa State at the time when President Obasanjo was also elected or being considered for presidency. And of course, he nominated Governor Atiku then as his running mate. So there was a controversy whether the deputy governor of Adamawa State then could automatically step into the shoes of the governor who is now being nominated to be vice president. And the matter went as far up to the Supreme Court. And what has been laid down as a principle of law for us in this nation now is that the ticket of the president and the governor is a joint ticket between the president and his deputy, and his vice president rather, and also between the governor and his deputy. So they cannot be isolated. There is no provision by which a political party could leave a presidential candidate empty without simultaneously having a running mate or a deputy governor.
Mr. Adegboruwa,
so you cannot...
pardon me, but in the case, let's just hypothesize, in the case of the death of a running mate, for example, if there were to be a replacement, are you saying that you have to replace the candidate itself?
No, I'm saying that the conditions in the INEC, in the Electoral Act rather, are quite clear. The circumstance of death is being simplified in the Electoral Act. You would inform the commission, and then you have to conduct a fresh primary.
For the running mate now. I'm saying for the running mate.
Yes.
In the case of the death of a running mate.
No, there's no such provision. There's a lacuna in the Electoral Act. There's no provision for a death of a running mate. What the Electoral Act says is a candidate.
So, in
there's
the same
no provision
case,
in the Electoral Act
the Section 31
to running mate at all.
Right, Section 31 of the Electoral Act, of course, doesn't mention running mates. It just focuses on the candidate. So maybe that lacuna can also be exploited.
That's the point I made to you first, that we take this back to the National Assembly, because we've checked through the Electoral Act. There's no, the Electoral Act didn't talk about the running mate or the deputy governor. That's why some people call them dummy mates. That's why the political parties say they are placeholders. So for us, there is that lacuna, and the best way is to resolve it on the side of a decision of the Supreme Court, which has already served as a guide. And that decision says that you cannot leave a sole candidate for the office of president or governor without having simultaneously a deputy.
So, Mr. Adegboruwa, an interesting thought just came to my mind, and I'm thinking, so the parties know how to arrange themselves. They call it a party affair. They eventually come to a consensus and do whatever it is they want to do. But for an onlooker, an average Nigerian, a lawyer, civil society, thinking, well, this is not the way we should carry on with our democracy. Can you challenge this in court? I know there's always a talk about locus standi and all of that. Maybe the court saying, what's your business in all of this? You're not a member of the political party. So is that something that can be explored, maybe as a way to even, boost or improve our democracy as a whole?
No, Kade, honestly, there's no need for this controversy. There's no need at all. INEC released its guidelines to the political parties. They knew they had the time. The controversy, for instance, that went on for so long in the All Progressive Congress as to whether there is a preferred candidate from the president, there is an anointed candidate. They had all the time. So they shouldn't come and force any urgency on the people of Nigeria. We should talk to our political leaders. They should play according to the rules. There's no need for this controversy at all. So it is for them to comply with the Electoral Act and ensure that there is sufficient overture on their part to play according to the rules. But I have sympathy for the politicians in what they have forced on us, to the extent that it is possible for us to go to court to challenge or find a way out. But it's too late now, because you can't hold another primary election, presidential election again. It can only be for another election.
But you just said,
do this for the yeah.
You don't forget, Mr. Adegboruwa, you said that there is no particular law, or at least there's no section that deals with the running mate. So if you say they should play according to the rule of the game or the law, there's no rule for this one, which is why I'm asking. Yes, I mean, we can wait on the National Assembly. Don't forget, they're still trying to get the president to assent to, in fact, they couldn't get the president. They couldn't, of course, override as of now. So maybe waiting for the National Assembly to go through this process might take some time. So I'm saying, for people who think that this is not the way to go, let's find a way to challenge this. Could that be another option for them?
Yes, it's possible, but like I said, it will not be to the purpose of the current exercise. And Kayode, honestly, it's not that we did not have anything to go by. INEC released guidelines, and those guidelines also talked about running mates. And the INEC guideline has been recognized by the court as part of documents to consider, in determining issues relating to election. Apart from that, I think some of the political parties themselves also made guidelines on how to bring about a running mate. For instance, I think maybe in the People's Democratic Party, there has to be a consultation between the candidates and the political party, or probably there has to be some kind of election, within their own executive or within the stakeholders. So they had all the opportunities. But I agree with you that in the light of the confusion going on presently, it is good to get to the judiciary to resolve it, and remove the controversies, so that going forward, we'll have a clear pathway we can follow when other matters like this will arise.
Well, thank you very much indeed for your time and perspective this morning, Mr. Adegboruwa, Senior Advocate of Nigeria.
Thank you very much. It's my pleasure, sir.
Sunrise Daily returns in just a moment. Stay with us.